Well, welcome everybody to the ThinkHouse seminar on getting back to work safely, legally and productively. Thank you very much for joining us and joining us so promptly. We all know that, of course, back in March, we had the mandatory lockdown introduced in the UK. Retail and public places were closed, except for food and essential services. Schools have been closed and everybody has to stay at home unless it's essential. And of course, some businesses had no choice but to close. Legally, many retailers had to close unless it was food and essential services. But of course, other businesses closed or heavily reduced activities because they just were not able to operate with everyone at home. So although factories, offices, warehouses, construction sites didn't have to at law close, many have or heavily reduced their activities. And of course, we all know about the massive economic impact that has had. And then we've all watched Boris Johnson, our Prime Minister, on Sunday night, telling us about the government's plan to see if we can emerge from the lockdown. And the message, at least in England, has moved from stay at home to stay alert. Now, we've had some minimal relaxation, at least in May, of some of the restrictions. So we can all now go fishing, play golf, play tennis, sunbathe as much as we want, and even talk to one other person outside our household 2 meters away. But more importantly for business was the message from government, who said that if you can't work at home, then you should go back to work, but subject to social distancing. And so, of course, for businesses, we're all scrambling to understand, well, just what does that mean? Does that mean that I have to reopen? How much money do I have to spend? What does social distancing at work mean? And therefore, I've gathered here today two of my partners, Andrew Lichfield, who's a specialist in regulatory crime and a particular focus on health and safety, and Jonathan Chamberlain, who's a partner in our employment team, recognising that at the heart of this is big health and safety issue about social distancing at work and employers' responsibility for health and safety. But of course, this is all about people and our employees. What happens if they don't want to come back to work? If you have any questions, please type them into the Q&A. I'm going to quiz Andrew first and then turn to Jonathan, and then I'll pick up your questions. Timing wise, we're aiming for this to be about 45 minutes, and certainly 4 p.m. we will finish. The session is recorded, and a link will be distributed to all of you and will be available on our website early next week. Those of you who are solicitors and barristers who are concerned about your continued practice development, we are an accredited training provider, and that means that you will get the equivalent of points. It's important you keep your own training record. We do keep a record that you attended this webinar. And finally, of course, health and safety and the employment issues from that are not the only COVID-19 issues, whether it's furloughing or force majeure clauses. On our website and our COVID-19 hub, we've got a huge range of materials dealing with that. Hi, turning to Andrew. Andrew, I mean, is there any new law here?
Good afternoon, everybody. Hi. Well, as you mentioned just in the beginning as you were speaking there, we've got a bit of new law. The Health Protection Coronavirus Restrictions England regs, snappily titled, are the things that shut us down about 6 or 7 weeks ago. But we don't have any specific new health and safety law. So what we're doing is we're falling back on and relying on the old existing health and safety law stuff, which has been around since the mid-1970s. Health and Safety at Work Act 1974 and the regulations passed subsequently underneath that overarching act. And it will be, there's nothing new about it, it will be familiar to many, many people. I'm sensing perhaps that those organisations which are mainly office-based are learning more about the Health and Safety at Work Act than they have perhaps had to know about before. So it's worth, I think, going through a little bit of law to understand how it works and why it's actually okay to rely back on it in the face of COVID. The good news about health and safety law is that actually all you need to know fundamentally is 2 sections of the Health and Safety at Work Act. And those two sections are as follows, and they're very similar. You really only need to know 1.5 sections. Section 2 is the section which sets up the duty that an employer owes to their employees. And it says it's the duty of every employer to ensure, just pause on the word ensure, so far as reasonably practicable, the health, safety and welfare at work of all his employees. So that's the section 2 basic overarching duty. Section 3, very, very similar. The duty of every employer to conduct his undertaking in such a way as to ensure, so far as reasonably practicable, that anyone who's affected by the undertaking is not exposed to a risk to their health and safety. So 2 sections, 1 act. If we get those right, if those 2 duties are discharged, all will be well. Section 2 is the duty that an employer owes to their employees, and section 3 is the duty that they owe to anybody else who's affected by what they do. But just a few points to mention in relation to those 2 sections. I mentioned ensure. Ensure is a very high burden. Make certain to happen is what the dictionary says when I looked it up the other day. So you have to make certain that people are not exposed to risk. And risk has been held by the courts to mean the possibility of danger. So it's pretty challenging stuff. And this is not COVID related. This applies to every risk that a business might come across. Ensure that people are not exposed to risk so far as reasonably possible. The scary part is that breaching those 2 sections is a criminal offence by the employer. And sitting behind that, which I won't go into now, but sitting behind that are the possibility of offences by individuals as well under the Act. But breach is a criminal offence. If you were to be convicted of that criminal offence, the employer would face an unlimited fine, and that fine is uninsurable. So it's coming straight off the bottom line. And also, you can't contract out of that duty. So you can't enter into a contract with somebody else, a supplier, a facilities management company, or anybody which passes that risk on to anybody else. So those are these 2 sections are the 2 sections, the 2 bits of legislation which are most frequently investigated and prosecuted by the Health and Safety Executive and local authorities. And they have already started to investigate and enforce those 2 sections in relation to COVID. So they're being applied to the COVID risk that we've now got. And you'll have seen in the press reports about extra funding going to the HSE and about people being encouraged to report anything that they're concerned about to the HSE and via the trade union or direct. But I think it's worth noting that that duty, it's a reciprocal duty. So it applies to your employees wherever they are, whether they're in your offices or on your sites, but also if they're visiting other people, you owe them that duty. But it also applies to the employers who are sending their people to you. So visitors into your premises, onto your sites, are also owed that duty by their own employers. So it's a reciprocal duty, and everybody effectively should be cooperating, coordinating with each other to make sure that it's possible for both sides, or everybody affected, to be discharging that. So no, we don't have any new specific health and safety law, but what we do have is a new, very challenging, very difficult risk affecting everybody, all of us, all the time, at work, at home, commuting, but it definitely comes into the workplace, and existing health and safety legislation is being used to make sure we manage it.
So obviously, given the nature of COVID, it's not possible to totally eliminate the risk of COVID-19 in the workplace. And so I suppose it all turns on as much as reasonably practicable. So if you're an employer and you're wanting to reopen your workplace, what does that actually mean they need to do?
So first, I think is to check those regs, the snappily titled regs that I mentioned at the beginning, to make sure that you're legally allowed to reopen your workspace. I've had some interesting for lawyers anyway, debates recently about what a shop is, for example, and what you can do in relation to open spaces. So check those regs, check that the government that what you are about to do, you're allowed to do in accordance with the regs and any subsequent amendments to those regs. But assuming you are allowed to open, then essentially what we have to do is to apply the old law to the new risk. And as with every other risk, what the law also requires you to do is to do a risk assessment. If you have to ensure that people are not being exposed to risk, then you've got to work out what your risk is in the first place. So you need to do a comprehensive COVID-specific risk assessment, and that needs to be site-specific, it needs to be task-specific, and it needs to be individual-specific. And they can filter down to the point where actually what you're effectively doing is assessing whether any particular individual in any particular place can be effectively managed against the transmission risk of COVID as a result of that risk assessment. And it's worth noting as in passing that, and this has also been the case, that it is a legal requirement to consult with your employees and with employee representatives in the preparation of those risk assessments. Those risk assessments will spew out control measures. Those are the practical things that you have to do in order to manage the risks which you've just identified in your risk assessment. And that's where the control measures need to be closely linked to and made by reference to the government guidelines, to PHE guidelines, and increasingly now to industry standards and industry guidelines, which are now starting to be produced in ever-growing numbers. So it's all roads in health and safety lead to those two sections of the Health and Safety Work Act, and then they also, passing those two sections, lead to risk assessment, and risk assessment is the basis of everything that business needs to do. Three points just on risk assessment. Sorry, David, just 3 quick points. One, those risk assessments need to be kept under review. In the 6 or 7 weeks that we've been in this situation, there's already been a huge change in what we understand about the risk, what we know about the risk, what the guidance is. So those assessments need to be kept under review. Secondly, I think it's easy to put into place control measures which deal with the COVID risk. I worry that sometimes in doing that, you might reintroduce risks which were previously well managed. So taking steps to deal with COVID might reintroduce other risks, which also now need to be managed. If you're changing your working practices to deal with COVID, you might also need to make sure you're not reintroducing other risks. The obvious example, of course, is working from home. We're all working from home. That deals with the COVID risk, or it substantially reduces the COVID risk. But what it might do is introduce workplace workstation risk, which we were more effectively able to manage if we were all in the office. So therefore, you might need to take steps to review what you're doing in relation to workstation risk, because everyone's now perched at home, maybe on the kitchen table. And then finally, and this is a new requirement, and it's guidance as opposed to requirement, but you may well have seen that you're required to share that risk assessment and publicise that risk assessment internally on the website, which I think mainly is about giving people confidence that the problem has been thought about and steps have been taken as a result.
Okay, so you check the law to make sure you can open, that you're not a retailer that's restricted or whatever. You then go and read the government guidance, which may be specific to your type of workplace, but maybe in things like PPE. You then do the risk assessments, as you described, site-specific, task-specific, individual-specific. And then you also stop and think, have I changed the profile of any other risks that I need to think about?
Yep, and you do that in consultation with your people, and then you publicise the output.
Gotcha. So, I mean, how detailed is this government guidance? Let's take offices. Is it the government specifically setting out how you're meant to ensure that people are more than 2 meters away from each other? Is it that specific?
It's quite specific in that, and there are different sets of guidelines applying to different industries and different general circumstances. So it's more prescriptive than normal health and safety legislation would be. So it's not, but it's principle based. It's still principle based, and ultimately, in order for Gowling's to manage the risk that it might face when it opens its offices again, for example, it depends. We have our own offices, we have our own working patterns, we have our own people, we have our own lift system, we have our own entrance requirements. So we'll follow the principles set out in the government guidelines, but apply them in detail to the particular circumstances that we face as a business.
So ultimately, the employer's got to make a judgment, and there's a risk they might get that judgment wrong, which we'll only discover with hindsight.
Yeah, they'll discover it. Hopefully, they'll if they consult and think carefully and look around corners in relation to the risk that they face, and they're well informed about the nature of the risk, and they're well informed about the control measures that would work. Hopefully, they won't get it wrong. If they keep it under review, they won't be wrong for long. So you definitely need to do those two things. And once those working practices are in place, you don't really know how effective a working practice is going to be until you've tried it for a while. So you need to keep consulting with the employees and keep consulting with the people who are visiting you to see whether that's working. And you need to stay in touch with what everybody else is doing in the industry and what the government guidance and the industry standard guidance is, in order to make sure you're as close to the edge of the curve as you can be.
Is it a good idea then to perhaps pilot arrangements just to try it out with a small number of employees to see if it works?
I think so. Yes. It's going to give you lots of information. It's going to give you some data. It's going to give you some feedback from those employees as to what's working and what's not working, what's difficult to do, what's not difficult to do. I think it's a good toe in the water. And while the government is keen to encourage everybody to go back to work, they followed up fairly quickly to say that they didn't expect it to be a rush. And I think that it'll depend a little bit on the industry and a little bit about what you're doing, but I think a pilot scheme, or I don't know, opening one floor of an office or opening a department first might be a sensible way to go.
And employers looking at the guidance in certain types of workspaces might conclude, well, if I do all of this and comply with it, the letter of this guidance, I'm not going to make any money. It's going to be unprofitable. My factory is only going to be able to operate at 20%. Is that relevant to the law in judging that employer's responsibilities?
Health and safety law in an enforcement context would look at cutting corners to save money or increase profit as a serious aggravating feature. So there wouldn't be a lot of sympathy from the court to an employer who is overly motivated by money at the expense of exposing people to an poorly understood or badly understood risk that they may face having brought them back into the workplace. So that's a tough one, and it may mean and may lead to hard decisions about whether it's worth it or not. But it also may lead to discussions and conversations about whether there's anything to do, innovation. It might drive all sorts of changes which may make things better in the long run.
It may mean some employers decide they can't open yet because they can't do so profitably, and therefore they're just going to carry on hibernating.
I'm afraid so. If it can't be done safely, then I think that enforcement action against somebody trying to do that, an investigation may well follow, and it would be a dangerous thing to do given the sanction and the publicity risk, the adverse publicity risk of an investigation. So
an employer complies with all this, the workplace is open, unfortunately an employee still catches COVID-19 at work. Is the employer going to be liable for that?
I think the key thing about that question is the way you asked it, because you said if the employer catches COVID-19 at work, and the challenge that any claimant might have in relation to bringing a claim for that would be to prove that they got it at work as opposed to anywhere else. This is a highly unusual risk in the sense that it's everywhere, potentially everywhere. It's not just something that you face when you're at work. It's in the community. So proving that you got it at work is going to be challenging. Having said that, and this says a great deal about the society that we live in. Somebody sent me some information earlier this week about the new registrations of companies and organisations such as Coronavirus Claims Limited. So I think there are absolutely opportunities being seen, or potential opportunities being seen, for claims to be brought along those lines. There are certain settings where it will be, of course, easier to prove that it was at work, or on the balance of probability, prove that it was at work, and care homes is the obvious one. So there's a big causation issue, but I don't think that will necessarily stop people from giving it a go.
And will your employer's liability insurance cover it?
Yeah, I mean, if the claim is put on the basis that and public liability insurance too, if the claim is put on the basis that this was something which is as a result of a breach by the employer, breach of those duties, breach of their general duty in negligence, then yes, that's something which you should definitely notify to your insurers, and your insurers should indemnify you.
So far we've been talking about the workplace, but of course the employee needs to get to the workplace, and that might well mean public transport. And we've all seen the pictures of the Victoria line earlier in this week when there was a disruption and people were having to be crammed into it. Is that anything to do with the employer? Does the employer have to consider that?
So strictly speaking, no. The legislation, as I referred to, speaks about being at work, and on your way to and from work, you're not at work. However, there are elements of this which are within the control of the employer, and you may well have seen government guidelines around staggering arrivals to and from work, making more car parking available, for example, in case people choose to drive instead of take public transport. There's a great deal of encouragement about active commuting, so cycling and walking, etc. And the employer can have some influence over all of those things. It is, of course, and then the entry points in and out of the site or the office are something which they definitely can control and make sure that there's no build-up of people trying to do that all at the same time. And there is some specific guidance. This is general to the general public rather than to employers, but that you'll have seen the government guidelines around safer travel and what the sorts of things that you might be able to do to make driving or make sharing a car safer. But of course, it's the right thing to do, isn't it? Fundamentally, you want your employees to come to work, you want them to go home, you want them to be safe, you want them to be well. That is a commercially sensible decision, apart from being just the right thing to do in any event. So I think I would encourage employers to include the commute as part of their risk assessment and see whether there's anything they can do to help ease that process and reassure people, make them confident, make them, encourage them to be at work and be working. Great.
Thank you, Andrew. I'll just have a quick look at the Q&A, see if I've got any. We've got lots of Q&As coming in here. Some of these will be for Jonathan. Let's have a look, see if there's any for you here. Oh yeah, commute to work was that question 2. We've covered that. Yeah, somebody said, and then just to be clear, Andrew, that somebody's asked, is the liability attached to them coming to place of work with the risk of catching COVID-19 on public transport? I think what I heard you saying is the employer should be thoughtful about it, but ultimately isn't liable for their journey to work.
Yeah, I think that's right, and I think that just adds to the whole causation problem that there will be in relation to any of these claims. How is the claimant going to prove on the balance of probability that it was that the transmission took place at work as opposed to on the bus or in public transport?
There's a. Can I just come in here, David?
Yeah,
to trail something I'm going to be talking about in a moment. There are aspects of the commute to work and how an employee can or cannot commute safely to work, which do matter in the employment context. So what I would hate for anybody to do now is to leave the webinar thinking, great, we don't have to worry about their commute, because you might have to. And we'll be coming on to that later in a few minutes, I think.
Yeah, absolutely. Don't worry, it's going to be one of the first questions, Jonathan. We've had here a question about publishing HS risk assessments. I think the answer, Andrew, is yes. The answer is internally it is.
The government guidance, what the government have said in their guidance, and its guidance, is that you should publish a risk assessment and they've said on the website. I think that my interpretation of that is it should be published internally and made available to the people who it affects, in general terms. There's another debate that could be had about whether there's any point in publishing a risk assessment. I think it's really all about reassurance and giving people confidence that the problem has been thought about. What you should really be publicising and banging on about are the control measures that emerge from the risk assessment, because those are the practical things which will stop the transmission of the disease. So a risk assessment which sets out, as they often do, a calculation of the scale and size and likelihood of the risk is okay, but it's not much practical help to somebody who wants to know how to behave in the workplace and where they should go and where they should stand and what they should do. So I think publicise the guidance is to publicise risk assessment, give people confidence that a detailed and comprehensive thought process has been gone through, and it will help the consultation process as well. If people look at it, they may want to comment on it, but the real important things to keep people safe are the control measures that emerge from the risk assessment.
Finally, before I turn to Jonathan, but I will come back to the rest of the Q&A at the end. Somebody's asked about responsibilities when you're working at home. We've been mainly concentrating about the workplace, but obviously if people can work at home, they should be working at home. What's the employer's responsibilities in relation to that?
Same as they ever were, really. Same as they were pre-COVID. We are all of us working from home. We are owed the same duty whether we're working from home or whether we're working from the office. Under the Section 2 of the Health and Safety Work Act, the employer has to ensure, as far as reasonably practical, that we're not exposed to risk. The key risk, probably, as working from home, funnily enough, is probably not COVID. It's probably upper limb disorders and everybody sort of huddled over their laptops on the sofa and getting neck and back and arm complaints. But the employer has the same duty to make sure that those risks are properly managed and do that again via risk assessment, by gathering data about where people are working, helping them with kit, helping them with information about taking breaks, etc. So those risks absolutely still need to be managed in the same way they ever were.
So employers who don't already have a working at home risk assessment need to get on and do one. And If you've already got a working at home risk assessment, now's a very good time to review it, now that it's your entire workforce rather than a smaller handful of people. Absolutely,
and this may well be continuing for many people for a good long time yet. So that if that risk assessment from working from home was based on maybe once or twice a week, well, it's now coming under a lot more serious stress than it was before. So it definitely needs a review and a refresh.
Great, thanks, Andrew. So, Jonathan, turning to you now, we talked about how to make the workplace safe and the employer's responsibilities, but of course, we need our employees to turn up for it to be meaningful. The Prime Minister's obviously encouraged everyone to go back to work if they can, and if you can't work at home, to go to work. Stay alert rather than stay at home. But do you have to go back to work?
Not necessarily is the answer. And I feel a bit lawyerish giving that answer, and I could almost hear a collective sigh from our 300 plus attendees. And indeed, the first question that's been asked on the Q&A is if we've made all the adjustments such as PPE, social distancing, and there's no reason such as shielding. If an employee refuses to come to work, can we take disciplinary action? And that's actually, we'll come on to explore that questionnaire. We will be getting to that. It's not simple though. And the reason it's not simple is that as Andrew has noted in relation to health and safety, there isn't any new employment law as such here. there is existing legislation which now has to apply to this, pick your cliche, unprecedented, unique, millennial set of circumstances. And it's not clear how a lot of the legislation, which was never designed for this, is actually going to apply, or how it's going to apply. So eventually, if an employee refuses to come to work in circumstances where it's clear they should come to work, but the business needs them to come to work, then yes, disciplinary action or even dismissal may be an appropriate sanction. But there's so much to go through before we get to that point. And what I'm not going to be able to do in this time, what no one can do at all, is give some of the clear, direct answers, the blanket rules, if you like, which will apply. What about childcare? What about commuting? Are these reasonable excuses or whatever not to come to work? They may be, is the short answer, and that's something that we need to explore.
So I think, Jonathan, you'd say as a starting point, as a good employer, you need to start by trying to persuade people that they can come to work and address their concerns before you start thinking about your big stick in your back pocket that you might need to deploy.
Yeah, well, that's absolutely right. I mean, let's talk about practicalities first rather than the law. What should an employer be doing in these circumstances? Well, building on what Andrew has said, firstly, an employer can't require an employee to come back to a workplace which isn't safe. And it's as simple as that. The duty to ensure, the word that Andrew highlighted, a safe place of work, means that if it isn't safe, the employee doesn't have to attend. And so that's the first thing that has to be done. But then, both as a matter of employee relations and as a matter of, in practice, employment law, what employers should be looking to do is to get buy-in from the workforce, to get acceptance from the workforce that the workplace is safe. So publishing the risk assessments and the control measures, as Andrew has already talked about, is part of that. But here's where employers need to use their imagination and accept that this is not going to be as simple as issuing instructions. You have to be back at work on this date, and if you don't, you will face disciplinary sanction. You may at some point be issuing those instructions, but not until quite a long way down the line. What you'll need to be doing first is telling employees what you've done, asking employees what they think you need to do. Andrew mentioned pilot groups. We know of one employer that has allowed colleagues to ask questions of the people who've been on the pilot. So we've seen, for example, construction companies have opened up one site, and then people who've worked on that site have been able to share their experiences with colleagues as to what's worked and as to what happened. Retailers might choose to open one shop first. These communications and consultations have to be led from the top. As Andrew mentioned, a lot of us who work in offices, frankly, we don't give much consideration to health and safety. We think if there's a trailing wire from a laptop that somebody's placed on a table, that, oh, better not show the health and safety people that, ha, 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 and that's how we approach it. Construction companies, manufacturing companies don't find that in the least bit funny, never have. Their safety efforts are led from the boardroom. And that's what everyone's going to have to be doing now, and being seen to be taking this seriously. So it's not just that employers are going to have to be saying, we've got to do this in the workplace to keep people safe. If people don't follow the instructions, they don't stand behind the lines that they're supposed to, they don't wear the PPE that they're supposed to, that somebody insists on going into the lift when there might only be one person in there, then disciplinary action is going to have to be taken against those people, regardless of their status in the company. So those are the practical things, if you like. Now, why do I say that? What's the law underpinning that? Well, there's a whole host of laws which might be applicable here. But the one which won't have had much attention up to now, particularly, frankly, in the office workplace, is the sections in the Employment Rights Act which deal with detriment to and dismissal of employees who raise concerns about an imminent and serious threat to their danger, rather, to their health and safety, or those of another. Such employees are protected against detriment, they are protected against dismissal. And there's a bit of well, I'm not sure if irony is the right word. This is legislation that was designed as a red button. You know, that this was something to be used in an emergency situation. That's what I meant at the beginning when I said that the legislation wasn't really designed for circumstances like this. But it's what we've got at the moment. And an employee who says, I can't come back to this workplace because I don't believe it's safe for me, or because I am shielding someone who's vulnerable at home, I don't believe it's safe for them if I have to come into this workplace because I'm at an increased risk of catching COVID-19 and transmitting it to them. They are protected if they have a reasonable belief in the truth of what they say. And that's why it's really important that employers communicate to employees what they're doing and that they do everything that they need to do so that when this is assessed months down the line by an employment tribunal, that it can be clearly seen that that belief wasn't reasonable. Now, we're dealing here with lots of unknowns, lots of uncertainties. What is a tribunal going to think in months' time? If we think it's difficult for us as employers, imagine how it's going to be for the employee. They want to know, do I have to go back? That's the question that you see being asked in employees forums, that people are asking of trade unions. Incidentally, by the way, trade union membership is going up massively. That when Boris Johnson announced that schools were to reopen, the recruitment pages of teachers' unions' websites crashed because they couldn't cope with the demand. People are really worried and frightened, and they are going to be asking these sorts of questions, and employers have to be ready to answer them. So that's just one aspect of the law that needs to be considered. There are others. Employees have always had the right, for several years, had the right to take time off in an emergency. An emergency doesn't mean something completely unexpected, because clearly COVID-19 isn't unexpected anymore. It doesn't mean that if your childcare has to have only fallen through 5 minutes ago, the law, the case law, takes into account and will take into account that in current circumstances, it's really hard for people to find replacement childcare in these circumstances. They are entitled to reasonable time off, albeit it doesn't have to be paid. Similarly, people are entitled to dependence leave if they give 21 days notice of it, which they might be able to do if they're given sufficient notice of coming back to work. So there is also, of course, the disability discrimination provisions, which might apply to somebody who is particularly vulnerable and they don't want to come back to work. They might apply in respect of somebody for whom they're caring, by the concept of associative discrimination. So there's that whole legal minefield which I've just laid out, and that's why I said right at the beginning that although ultimately you may be able to say to an employee, we need you back, there's no reason why you can't come back. If you don't come back, we're going to go through a disciplinary process. That process may result in sanction against you, including ultimately dismissal. But we're a long way down the line. And that's even before we've got to consider whether this dismissal in those circumstances would be within the reasonable range of responses for an employer. And here's where employers need to get creative with things like the furlough scheme, because there will be some employees who can come back and some who can't, for the reasons that we've talked about, who would find it particularly difficult. Well, you might think about, instead of firing those employees, of keeping them on furlough. And then only bringing them back later as you ramp up. And that's perfectly permissible. We have seen some employers saying things like, well, I can't make an exception for you because that wouldn't be fair on everybody else. That's not right. employers need to consider individual circumstances. They need to drill down to that level of detail.
Okay, so let's imagine we have somebody who has no children, is, I don't know, in their 30s, has no dependents, has none of the extras, is just a really simple employee. The employer, as we've heard from Andrew, needs to make the workplace safe, and obviously there's some debate about that, takes all the steps to make it safe, has pilots, engages with the workforce to say, this is what we've done, what do you think? And that person goes, no, I'd rather stay at home, watch Netflix, thanks. What I think you're saying is, frustrating as that might be, in reality, as an employer, you're going to have to engage with that person, because to get to the position of ultimately dismissing them is a long and torturous journey. So don't think you can just instantly sack them. I think that's what you're saying?
That's absolutely right, yes. So to take the example of the employee that you've just given. Well, they're refusing to come back, okay? Assuming they've got some sort of reason, and they don't actually say to you, no, it's because I haven't quite finished my box set yet. Those might be different circumstances. Then one of the questions, if they've got 2 years service, if they are protected against unfair dismissal, that a tribunal would be asking is, well, did you have to dismiss that employee? Or could you, for example, have brought in labour for a period until they were able to come back? Now, where this is going to get tight, you can see, for example, there will be small operations where a particular employee can make all the difference, and where somebody who can come back, who knows the ropes, who doesn't have to be trained, who can get the operations going, is the person that needs to come back. And if they, again, if we've jumped through all the hoops that you set out at the beginning of the question, then it may be appropriate to move towards disciplinary proceedings for that employee relatively early, if only so that they understand the seriousness of the situation. But there would have been a lot of communication before that actually happened.
Okay, so we talked about the commute to work, and Jonathan, you quite rightly flagged up health and safety and employment responsibilities are going to be slightly different. I know that our own teams, all of our people in our teams that's the key anxiety for many of them, is travelling on public transport to get to work. So if I'm somebody who can only get to work on public transport, I don't have my own car, and it's too far to walk or cycle, how does it work for them?
Well, thank you for picking that. Thank you for reminding me to pick that up. Yes, the protections I was talking about earlier, sections 4400 of the Employment Rights Act, to give them their full title, may well extend to the commute, such that if an employee has a reasonable belief that all the circumstances of the work, including the commute, constitute an immediate danger to their health and safety or that of another, then they may well be protected. Now, the law on that isn't clear. It's one of the many areas of that bit of legislation that isn't clear. What is serious and imminent danger, for example, in the case of COVID, where the danger is increasingly understood. But an employer would be most unwise not to take into account potential dangers on the commute before requiring an employee to come back to work.
Okay, so that's going to be quite tough, isn't it? Because your employees will probably get to work in lots of different ways, won't they? Some will cycle, some will walk, some will drive the car, some don't need to come to work, so they'll just be working at home. And then you've got this small a class of employee who might travel public transport. Some of them that's the train, some of them that's the bus, some of them that's the tube, all with different risk profiles. It's really difficult then, isn't it, for the employer?
It is really difficult. And it's it's particularly difficult for city centre employers, where public transport is often the only viable means to get in. People are not going to be able to cycle 20 miles to work, and even if they could, even if even if they could do 10 miles to work, then are they going to have the facilities to be able to park the bike, shower, change, etc., etc.? Even supposing they're physically capable of doing the cycle ride in the first place. So this is a particular issue for inner city employers, and I think we're going to have a lot of imaginative solutions around staggered commutes. And there's some commentators have said, well, you know, employers can't stagger commutes because they open when they open. Well, they may have to open at different times. And if that goes to profitability, then there are the issues which Andrew has already identified in relation to enforcement, in enforcement action. It may not be possible for some entity employers to open in the way that they did before until the disease is more under control, until it becomes clearer that public transport is safer or alternative arrangements have been made.
Okay, let's turn to the other sort of elephant in the room for most people, is around childcare. Nurseries are closed, schools are closed, at least until June. If you've got young children, you can't abandon them at home. How sort of employees unable to come to work for that, how does that play out?
Well, I'm glad you particularly asked that question, because it gives me the opportunity to correct a slip of the tongue I made earlier when I referred to dependent leave rather than parental leave. Because let's just break this down as to what it actually means if an employee says, I can't come back to work because of I can't get the childcare. Now, first question the employer needs to ask is, well, do I need you back to work now, or can I wait until you get the childcare? If the answer is, I can wait until you get the childcare, then the starting point would be probably wait until you get the childcare. If the childcare is necessary, have the conversation with the employer. We've got the situation where a big employer is reopening and a lot of employees are saying, I can't come back because of childcare. And there's childcare needs and childcare needs. There's childcare needs because I need somebody to look after my children, because otherwise they'll find themselves in the house. And the childcare says, my husband is studying for a degree and he first. I'm getting a message here up on my system that says that my microphone isn't working. Can you still hear me?
I can hear you now. You broke up briefly.
Okay, right. It seems to have come back. So drill down into the request is the first point. The second thing to say is, well, if you really do need this person back, and you press them, they may have the Section 44 argument. I think there is an imminent danger to the health of somebody I'm looking after, and I need childcare to release me from those duties, for example. They could say, I'd like some parental leave, please, some unpaid leave, so that I can look after my children. They could say, my childcare arrangement's fallen through and this is emergency leave, and I need a reasonable period of that. And they are protected against dismissal and detriment for making those requests. You may not, as an employer, be able to grant parental leave, both have still entitlements, so you'll need to work out how you can deal with that. Looking at this pragmatically in the situation that we're in now, and this is why I'm trying to stick away from giving absolute rules. As an employer, will you really be in the situation where the one employee who says, I can't come back for childcare reasons, means that either your operation can't go ahead, or there will be serious employee relations consequences as a result? And in some circumstances, there will be. If you run retail operations, you've only got 2 or 3 staff per shop, which is quite common, or full-time staff equivalents per shop. So the presence or absence of one person at a time makes a big difference in the rota, then you can see that that would be an issue. But for other employers, it may not be. it can be something that they can work around with the furlough scheme, keeping people on furlough until arrangements can change. And that scheme, we don't know how, but we know is going to taper out over time towards the end of the summer.
So what are the practical steps then that employers should be taking to try and mitigate all of these risks, Jonathan?
Communicate, listen, communicate. What Andrew said, repeated, about talking with workforce, talking with and listening.
Oh, you got mute. And you crackled a lot. Sorry, Jonathan, for that. I don't know if it's... Can you hear us?
Switch to a different microphone. Come back?
Yeah, you're here. I can hear you now.
Okay, right. Communicate. Talk to the workforce, to individual employees, listen to their concerns, try to work with them, lead from the front, lead from the top. And those would be the do's. The don'ts would be, don't make rigid rules for yourself. Try not to do things on principle. Be pragmatic and work with each individual case. Now, I know that's not going to sit easy because people want clarity. People want to know where they stand. Individuals often say that, I'll be okay so long as I know where I stand. They don't often mean it as much as they think they do. So I would be wary of looking to that as an objective. Don't make simplistic rules that are going to give yourself problems later on.
Thank you very much, Jonathan. So now looking at some of the questions coming through, we're going to, just to be upfront, there's more questions here than we're going to be able to answer in the next 10 minutes, but we will endeavour to offline answer those ones we don't get to today. One of the questions, Jonathan, is about how some countries are introducing the flexible working as a right at law. Do you think that might come down the tracks now that we've got used to potentially working much more flexibly?
I don't see any sign of that yet. I think the existing rules around the right to request flexible working may be prayed in aid a lot more often. And I suspect, and this is certainly what is being discussed in HR circles as well as legal circles at the moment, is that the result of this pandemic, perhaps a positive result of this pandemic, may well be that employers are a lot more amenable to flexible working requests. Many organisations said, we can't have everyone working from home, and have discovered they can have everyone working from home. So I don't see any change in the law. I do see changes in working practices. I think that's very likely.
Somebody's asked about journeys to work. If somebody chooses to cycle to work, because obviously that's safer, that's recommended by the government, but it's going to be an hour cycle ride in and an hour cycle ride home. Can they insist on a shorter working week to absorb that commute time?
Can they insist? Ultimately, no. I mean, ultimately, an employee is unlikely to be in a position where they can make a categoric demand like that. Can they insist that an employer listens to that request and discusses it seriously with them, which may uncover that, for example, I need to cycle into work because I can't take the risk on public transport. I can see that you have done everything you can in the workplace for me, and so I feel safe when I'm here, but I'm not safe on the tube. And actually, because of how far away I live, then if I'm going to cycle in, if I'm going to get home before midnight every night or whenever, I need a shorter working week. That may well be something that you put in place for that employee for a time. Try it as a pilot scheme, see if it works. try it for the length of the of the epidemic. If you're a big employer and you can absorb that cost, if you're a small employer and you can't, you're in a much stronger position to say no. What you can't do and mustn't do is sack somebody for asking.
Turning to Andrew. Andrew, there's lots of questions coming in here about risk assessment. So let's see if I can knock off some of them. The first thing, is it a legal obligation to carry out a consultation with your employees about your risk assessment?
Yes.
Thank you. And does that even apply if you're a small business?
Oh, good question. There are some of the more onerous requirements. For example, recording it in writing, which don't apply if you employ less than 5 employees. So it depends a little bit, but you have to be right down at that kind of scale before you get let off some of the of those requirements.
So more the micro business scale rather than merely small.
Yeah.
On posting the assessments, I think there's lots of questions which I think people may have misheard. You don't have to post it on your external website.
Well, the government guidance says you're encouraged to put it on your website. Now, I suspect that nobody's really thought about the difference between an internal website and an external website, and it's guidance as opposed to a statutory requirement in any event. So I have interpreted that. This is a personal view, but I think that means internal website. I think it means making it available to the people who are going to be interested in what it says, and you can do that by doing that internally. So that's a personal view. It's a personal interpretation, but I think it's on your internal website. But we've only had that since probably earlier this week, and I watched this space as to exactly what the government intended. But the purpose of it is to make sure that it's done, surely, to keep people honest, to make sure that it's properly done and thought through, and can therefore have questions asked about it and possibly challenged if people think it's not good enough. The only people it's truly relevant to are the people who are affected by its outcomes. So I'd say internal. Yeah.
So do a risk assessment, do all the consultation, publish it internally, publish it on your intranet. Hang back, don't stick it on your external website unless you've got a real appetite to, until you see what the emerging practice and interpretation is what I'm hearing.
I think so, yes, I think so. And I mean, if a regulator, the HSE, comes and asks for it, then you'll have to provide it to them. So it will be available. I don't think there's any secret to it. I just think it's an internally based process, an internally based document for the moment. And as we've discussed, that's the point of it.
Some people have asked about who you consult with. If you haven't got trade union reps or formal employee reps, what do you do?
I was having a conversation with a client about this actually just before we came on the call. Often there may well be a health and safety committee, something that can be put on the agenda of the health and safety committee. There may well be just simply having a pilot scheme, running it, seeing what people think, talking to people about that. That's a consultation. Anything is better than nothing. Reviewing and amending it and keeping it real is important as well. There's no one size fits all method that you have to consult, and I think probably you have to demonstrate that what you've done is a genuine attempt to seek the views of the people who are in the best position to tell you what's safe or what's not safe. Are the people who are on the ground doing the job? Makes sense anyway to consult with them because they're in the best position to tell you what's hazardous and what isn't. So it goes to making a decent risk assessment in the first place. But I don't think there's any one size fits all, and I think it's important to, something is better than nothing, and the more you can do, the better.
Right. I promised we'd get this wrapped up for 4. So firstly, those people we haven't answered the questions, we will endeavour after this to sort of type in the answers to provide that response. Sorry, we've had more than 30 questions, which is fantastic. Just Andrew, Jonathan, just ask you for some closing remarks. Andrew, starting with you.
what I said at the beginning, really, no new law, but we've got a big new risk, unprecedented, never had to deal with anything like this before. But we do have a long established set of principles and methodologies from general health and safety risk management. Those principles and methodologies, if they're properly applied to this risk, will generate means of being able to operate safely. And it's a question of applying those methodologies to the new risk, keeping them under review, keeping them evolving, and then hopefully we can, it won't ever be the same, but we can do business sooner than perhaps we feared.
Jonathan?
Win employees' hearts and minds, win their trust. And with that, you will avoid even having to delve into the complexity of the legal issues. If that's not working and you need to think in coercive terms, make sure that you drill down into each employee's situation. Don't work on the basis of blanket rules that you apply across the organisation. That is going to lead you into trouble.
Right. Well, Andrew and Jonathan, thank you both. This is brand new law and fast developing, so thank you very much for sharing your time today. As I said, this webinar has been recorded and will be on our website, and a link will be sent to you. We will endeavour to answer the questions that people have provided. By all means, contact any of the three speakers today, including myself, if you have any questions that occur to you afterwards. And also on our COVID-19 hub on our website, you will find a huge range of materials, and there will be materials being developed talking about the issues we talked about today as it becomes clearer. So thank you very much for attending.